greatest form of control is where you think you're free when you're being fundamentally manipulated and dictated to. One form of dictatorship is being in a prison cell and you can see the bars and touch it. The other one is sitting in a prison cell but you can't see the bar, you think you're free. What the human race is suffering from is mass hypnosis. We are being hypnotized by people like this. Newsreaders, politicians, teachers, lecturers. We are in a country and in a world that is being run by unbelievably sick people. The chasm between what we're told is going on and what is really going on is absolutely enormous.
Yes, hello. Thank you for joining me for another episode of the Red Pill Hardcore TV show. And yes, I want to say that there's lots of things going on behind the scenes. I don't know if you guys are following the director, marketing director, and whatnot. I don't post that much on my Facebook page, although you can go to it and message me. I do get those messages. And things are just popping off. Things are in a way that, yeah, we're speaking truth. We're activists. Real journalists, real correspondents, real commentators should also be activists. And that's really sort of the theme of the show. See, Mr. John Gentry, whom did a wonderful presentation. He's a public speaker who is really awesome. I mean, he is doing phenomenal work because he's taking the issues to the man. Okay, it's one thing just to talk, and not do anything. But the man is bringing all these issues of corruption to the courthouse. You know, we the people have to hold the government accountable for all their wrongdoings. I mean, we're held for everything that we do. You get pulled over for speeding, you get a ticket, and what are you gonna do? You're gonna crumble it up and throw it at the cop and tell him to eat it? You know, so the consequences for everything. We must be sure that our public servants know that they are not above the law. There are laws for a reason, and we all must abide by them, especially when it's we the people who make these laws. So, again, this is a presentation from John Gentry. He's kicking butt. It's just like me. We're taking all these issues, everything that's happened to us, the attacks on the show, the attacks on business partners, everything has been documented and everything is being dealt with accordingly. I know I have a lot of supporters out there and I love all the feedback. And hey, all I can do is keep pushing on. But please also support John Gentry.
He's a former Force Recon Marine, one of the most intelligent people I know, Mr. John Gentry.
Thanks. Can you guys hear me okay?
Yes.
Today we come to remember Nancy Schaefer. But let's best remember her by taking up her fight and demanding reform. Reigniting the torch that she lit, demanding reform of Child Protective Services and state laws that have been put in place and federal laws that have been put in place that incentivize the government to take away children and to deprive us of our rights. We need to take that fight back up and push it out across the country.
Yeah!
The injustices that Nancy advocated against haven't gone away. They've only worsened, and they're going to continue to get worse. I guarantee it. That's how this process works. It's little by little, more by more. While these state agencies are certainly culpable for wrongfully taking away children, they could not be taken away except for what happens with our judiciary. And I think we're seeing a common theme here today, haven't we? There's a big problem in our judiciary. For the viewers out there watching on YouTube as this is shared and replayed, I think you're going to want to listen to this. This is really important about how we bring about reform of this broken legal system and to understand how we got to where we are today. Thomas Jefferson in 1821, he predicted this is what's going to happen. Thomas Jefferson wrote, "The germ of destruction of our nation is in the power of the judiciary. An irresponsible body gaining a little today and a little tomorrow and advancing its noiseless step like a thief over the field of jurisdiction until all shall render powerless the checks of one branch over the other and will become as venal and oppressive as the government from which we separated." We have come full circle and we're right back to the same things that we declared our independence from Great Britain. We're right back to the same mock trials that they suffered, we now suffer. By the way, when he said venal and oppressive, venal means influence for sale. And that's what justice is today, is it's for sale. I don't argue that all members of the judiciary are corrupt or that all proceedings are corrupt. But when it does happen, and it happens, I think, from my experience, and certainly from your experience, it happens more often than not. But when it does happen, the judiciary fails to provide any oversight, and it protects that conduct. I don't know, Ted, can we blow that up a little bit, or is that as big as it gets? Well, this is a chart. It's available online. This is an auditor's compilation report. I prepared this for a gentleman in Florida, and he submitted it to our U.S. Congress Judicial Oversight Committee. And I've shared this around in a few places, and my name is John Gentry. You can find me on social media, and I would be happy to send you a copy of this. But this report shows that 96.5% of complaints filed against judges are dismissed. 96.5%. The 3.5% that are acted upon is only when there's infighting between corrupt members of the judiciary or legal professionals, and generally only then when a more powerful legal law firm has a beef with a member of a less powerful law firm or a less powerful member of the judiciary. Those are the only complaints that they act on. That's a violation of our equal protection. We have a right to have access to file complaints against judges. Ted, can we go to that next one?
Yep, working on it.
Ted's going to bring up this next chart in a second. And it shows that primarily the complaints that are filed against judges are filed by litigants. More than other court workers or other judges, the highest number is coming from the litigants. And it shows that a lot of it is coming out of domestic relations cases and family court cases. How can it be so hard to divide up the assets of two people that it results in these complaints? These charts will also show that it's due to legal error or improper procedure. How hard is it to not screw up the law when you're handling a family matter. The laws are clear, the rules are easy to follow, so why are there so many complaints? The reason is because they don't follow the law, and they violate rules repeatedly, and they know that they're doing it, and these judicial oversight agencies will do nothing about it. This report was compiled across 18 states, same story in every state. None of them do their job anywhere. It's because of the gross negligence and the aiding and abetting of those judicial oversight agencies that the misconduct occurs in the state courts. Ted, can you get that one for the CNN? Can you bring that one up?
Yep.
I was really surprised to find this article on CNN. They went out and analyzed in the federal court system. So this report, that auditor's compilation report, was on the state judicial oversight agencies. CNN did an investigative report into federal judicial misconduct. And there's on average over 1,000 complaints a year filed against federal court judges. In this is the article, CNN investigation, sexual misconduct by judges kept under wraps. Now, I believe that we're on the cusp of change by the fact that this article was published by a liberal mainstream media. The system, I think, has become so corrupt that we know that change needs to happen. I think that the fact that we elected a president outside of the establishment shows that the people are demanding reform, demanding a return to the Republican principles that our country was founded on. And the fact that these guys wrote this report gives me hope, because I think probably many of you out here and the viewers out there on social media who are watching this have written to your local papers, called them up, and they won't tell the story. So it is astounding to me that CNN put this out there. The reporter stated in the article, but the judiciary itself is hiding the depth of the problem of misconduct by judges. He went on to say in this article, very few cases against judges are deeply investigated, and very few judges are disciplined in any way. In many years, not a single judge is sanctioned. He goes on and he says, none of the actual complaints, more than 1,000 filed annually, are made public in the public judicial orders, and that's where the Judicial Oversight Committee will publish something. The claims are sparingly summarized, and accused judges' names rarely appear. So you don't know who they did or what they did. Judicial orders, again, these are the rulings by these judicial oversight committees. They're dumped onto circuit court websites as a series of numbered fields with no indication of allegations, person complaining, or the outcome. So it's amazing to me that CNN reported that. Clearly, there is no oversight of our judiciary, and they can do whatever they want to us, and they're not going to hold themselves accountable. Justice Gorsuch, our most recent Supreme Court justice, during a meeting, I believe it was with a Senator Haas, when a Supreme Court nominee is appointed, they will typically do one-on-one with members of the Senate and the House. And I believe he was with Senator Haas, and this was reported in the New York Times. He said, whenever there's an attack or a criticism on any judge, it's an attack or criticism against all brothers and sisters who wear the robe. So how do we find justice when the people who are hearing our cases and complaints against judges are taking it as a personal attack and a personal criticism? This is a fraternal code in how the system protects itself. In 1822, Tennessee, this stuff is not, it's nothing new. This has been going on for hundreds, probably thousands of years. We've just come to a point where I think that we're at a tipping point now, and the pendulum is going to start swinging the other way. In 1822, Tennessee's third governor, Governor Carroll, he stated to the Tennessee General Assembly, "A well-regulated, independent judiciary is so essential to the character of a state that it has a strong claim upon your attention at all times." Our state governments have forsaken their Republican character. They in no way reflect Republican character. A state being Republican in character, one of the basic tenets of that is being able to address grievances against the state. And we have no means to address grievances against the state. You file a complaint against the judge, whether you do it in his personal capacity or his official capacity. In his personal capacity, they say, "Oh, judicial immunity, you can't sue." And you're suing him in his official capacity. Well, state sovereignty extends to him, and you can't sue him either. You complain to the judicial oversight. We see what they do. They dismiss all of the complaints. So let's assume these legal arguments that they make are true. Judicial immunity, sovereign immunity. They throw in Rooker-Feldman in federal court, can't challenge state court judgments. So if that's all true, how do we enforce our right of due process? We can't. That right has been usurped. We are deprived of that right. Our 5th and 14th Amendment right of due process has been rendered void. The Constitution has been made null. We hear so much recently about Second Amendment rights and a right to bear arms. Why isn't our 14th and 5th Amendment rights spoken about? I think, and this is kind of how this broken system perpetuates itself. I think when a young lawyer graduates law school, and when they make the decision to go to law school, except if they're coming out of the privileged class, but if it's somebody coming out of the general public who wants to become a member of the bar, they have they have a sincere interest in protecting the rights and protecting the interests of their client. And when they get in and they see the reality of what happens in court proceedings, and they start to stand up for it, these attorneys are called in front of their state Supreme Court, or they're called in front of their state bar, and they say, young man, young lady, we have ethical rules, our rules of professional responsibility, which you're bound to according to your oath when you were admitted to the bar. And it says that you will not bring the judiciary into disrepute. And that's what you're doing right now by complaining against your client's rights being violated by this judge. You're bringing that judge into disrepute. Now, this can't happen, so we're going to disbar you, and you can figure out some other way to pay for your student loans. And that's how the system perpetuates itself. So once that young attorney gets ingrained to that, and they start enjoying the pecuniary, the monetary benefits, because they charge a lot of money, don't they? So once they start to enjoy that benefit of their inflated, ridiculous rates that they charge, then they start to kind of like it. And then they become part of the process. And just like Thomas Jefferson said, gaining a little, like gravity, growing by night and by day, a little today and a little tomorrow. And that's how this system progresses and perpetuates. And once they get into it, then the circle keeps repeating it. It keeps repeating itself. So that twisting of their ethical rules, that's how the system protects itself. So the judicial oversight agencies won't do anything. Don Rusty talked about taking this to federal court. Well, I've gone to federal court. I've been in federal court for a few years now. And I sued a judge just for equitable relief. I just say, I want a fair trial. That's all I want. I'm not suing him for money. I don't want anything out of it. And I would like the court, the federal court, to order him to adhere to the Constitution and provide due process to all the people that come after me. That's all I wanted. Pretty doggone reasonable, I think, right? Well, I said, judicial immunity, sovereign immunity, you can't sue him. Took it to the U.S. Sixth Circuit. U.S. Sixth Circuit said, the district court dismissed the case under Rooker-Feldman. I wasn't challenging judgments. I was complaining of the fact that my rights had been violated. And they said, so under the Rooker-Feldman doctrine, you can't bring this suit. So I defeated Rooker-Feldman, clearly, hands down, crushed the argument in the legal brief. And I get into the U.S. Sixth Circuit, and they say, we don't, we can look at all of the facts and all of the law, and yeah, Rooker-Feldman doesn't apply in this case, Mr. Gentry's right, but sovereign immunity and judicial immunity still apply, so case dismissed. Well, I'm not done. I'm in the United States Supreme Court with that case, and we'll see if I backed them up against the wall or not, and whether they'll clear my case. But here's the thing that we really have to understand. If judicial oversight agencies were doing their job, misconduct would not occur. You cannot defeat that argument by any means. The first time a judge violated ethical rules or the canons under the codes of conduct for judges, they would go to these judicial oversight agencies, and if they were doing their job, they might do it once and then it wouldn't happen again. And that would set the example that it wouldn't happen at all. So it has to be true that because there are rights violations, and we all know that there are, it has to be true that these judicial oversight agencies are not doing their job. Now, these guys can't get away with it in the judicial oversight agencies because that's nothing but aiding and abetting rights violations, and they're guilty as principal in these judicial oversight agencies. And they're subject to criminal law, for one, 18 U.S.C. Section 1346, honest services, failure to provide honest services. They're culpable under that. But the fact that these judicial oversight agencies can do that, it has to be true that the district courts will not enforce the Constitution against these guys. And it's true. You can go through the U.S. district courts across this country, and every one of them dismisses cases against judges. They protect the system. Like Gorsuch said, any attack on any judge is an attack on all the brothers and sisters who wear the robe. So the district courts. So now, for the district courts to wrongfully dismiss these cases, it has to be true that the circuit courts are going to affirm those dismissals. We saw it in my case. Brian Kinter saw it in his case. So the system is self-protecting itself for this corruption. Now, for the circuit courts to be able to wrongfully affirm dismissals against complaints against judges, it has to be true that they know that the Supreme Court is not going to grant certiorari in a case like this. So therein lies the problem. It goes straight to the top. It's our United States Supreme Court that is the problem, in my opinion. It is their unwillingness to exercise their supervisory power over the circuit courts and the district courts. They just don't grant cert. Sorry, we don't want to hear that case. We're not interested in it. So what the heck are we going to do? What's going to work? Media obviously isn't going to work. The legislature obviously isn't going to work. Ted, do you have the unconstitutional state statutes? So I think this is another one. I don't know how well you guys can see this. The state legislatures have been infiltrated by the legal profession. Many of the state legislators are legal professionals themselves, lawyers. It may not say it in their bio, but a lot of them have a bar license. So they enacted in Tennessee Code, and these laws that I'm going to show you guys, these are common across all of the states. This isn't just Tennessee. These guys all play ball together, and they're all doing the same thing. So TCA 292205, the language of this is really tricky. So removal of immunity for injury caused by negligent act or omission of employees. Exceptions, immunity for year 2000 computer calculation errors. What the hell does that mean? So removal of immunity for injury caused by negligent act or omissions, exceptions. So this is not, so when they say removing immunity, that's saying you can bring suit, you can sue them. But then they're saying, oh, well, there's these exceptions that we're going to throw in there. And so they said immunity from suit, and they kind of restate this. Immunity from suit of all government entities is removed for injury proximately caused by negligent act or omission of duty within the scope of its employment, except if the injury arises out of. Tricky lawyer language there, folks. So they're saying immunity is removed. Well, that sounds good. And when you scan it, you're like, wow, this is good. Except if. So the except if is the exercise or performance or the failure to exercise or perform a discretionary function. Who does that provide immunity to? Judicial oversight agencies. That's why they get away with it. They say, well, you can't sue. And this one, by the way, it pertains to I think this is the one, governmental entities. Yeah, so this is immunity for suit for all governmental entities. Remember, you can't sue the judge, sovereign immunity, judicial immunity. You can't sue the state, sovereign immunity. And so here they're closing the last gap, and they're doing governmental entities. This next one, I am just astounded, and I'm challenging this in the United States Supreme Court. False imprisonment pursuant to a minimus from a court. You know what that is? That's you're in contempt of court. You're going to jail, you know, or go pick him up. He's in contempt. False arrest, malicious prosecution, intentional trespass, abusive process, libel, slander, defeat, interference with contract rights, infliction of mental anguish, invasion of right of privacy, civil rights. They're saying you can't sue for all of those things. Why didn't they just throw murder in there too? I mean, good grief. These guys they're giving themselves a free ride. Do governmental entities do false arrest? Do governmental entities violate civil rights or invade privacy? No, those are bad actors in the state that do that. And this is the state closing the loophole on it. Ted, can you go down to the next one, please? There's another one in I think it was in the late 70s. Congress enacted 42 USC section 1983 through 86, I think. And 1983 is probably one of the most used parts of the USC in trying to find justice against corrupt judges. I think it's down. So under 42 USC 1983, any person that violates your rights is subject to civil suit. You can sue them. So that's a really easy one to use to sue a judge, and that opened it up for us to enforce our rights. Well, states didn't like that, so the states went out and enacted statute, and they said, "Oh, it's the next one after that." But I'm going to come back to that one a little bit more. Here you go. So personal tort actions, this is Tennessee Code 283104. And again, this is just Tennessee, but it's the same crap in your state. Personal tort actions against certain professionals, except as provided in subdivision, there's a 1-year statute of limitations. And it says civil rights Civil actions are for compensatory or punitive damages or both brought under the federal civil rights statutes. So what the state has done is they've set a time bar, statute of limitations on federal law. I don't think they have authority to do that. So I'm asking the Supreme Court to render that law null and void, because the states were never granted authority to set statute of limitations on federal law. And basically, you know, when you throw in a one-year statute of limitations, it makes it all but impossible, because by the time we educate ourselves and learn the law, we miss the one-year time bar. So let me step back for a minute. So Nancy's fight, the fight that I hope all of us here have chosen to engage in, it's not unique to Georgia, it's across the entire country. The annual reports that I just showed you prove that it's a fact, that there's no oversight of the judiciary. That CNN article also shows that there's no oversight of the judiciary. You know, I don't just go out and say, oh, well, the system's corrupt and we need reform. I show you and lay it out in facts and evidence and say, you know, here's the proof, guys. You know, there's no question here. Our president, in a recent executive order, he said, human rights abuse and corruption undermine the values that form the essential foundation of stable, secure, and functioning societies, have devastating impacts on individuals, weaken democratic institutions, degrade rule of law, perpetuate violent conflicts, facilitate the activities of dangerous persons, and undermine economic markets. This is exactly the same argument that I have made in federal court. He just said it a little bit better than I did. But it's exactly the same argument that I made in federal court. Devastating impact on individuals. You know, when you get into a bad situation with a corrupt judge, you know, all of a sudden they start appointing guardian ad litems. They start appointing the child protective services. They start appointing medical psychiatric professionals to evaluate the children, to evaluate the parents, and of course the parents all get billed for this stuff. By the way, I am not a victim of child family court by any means. I don't have kids at all. I'm in this fight because I saw how corrupt and broken this system is. And as a former U.S. Marine, I swore an oath to defend the Constitution against enemies foreign and domestic. And so I'm adhering to my oath and defending the Constitution. President Trump also, he said in his Warsaw speech that if we fail to protect human rights, it will never, ever exist again. And I think that he's right. We're at a tipping point. It's going to go one way or the other. Either we're done and we can just kiss all of our rights goodbye, or the pendulum is going to swing back to the Republican character and the Republican state that our founding fathers set up for us and provided for us. So here's how I propose that we address this problem. The media is not going to do anything. You can see here the state legislatures are in league with the judiciary and the legal profession. So the legislators are going to be absolutely no help at all. The district court, the federal district courts, the federal circuit courts are not going to help us. So how do we address this problem? We need to come together as a people and join hands and demand reform, and do it through a petition for a writ of cert, or an extraordinary writ, and a petition for mandamus in the United States Supreme Court. I've been working with Jeff Adkins. He's the I want to say he's chief deputy clerk, but he's a deputy clerk in charge of admissions in the United States Supreme Court. And I've been talking to Jeff about doing this case that I'm telling you guys about right now. And he's like, yeah, I'll docket it. You know, we'll put it in there and we'll see if the Supreme Court will hear the case. And so this complaint, this cause of action, extraordinary writ, and a petition for a writ of mandamus would be both in the same, both those two actions, extraordinary writ and mandamus in the same document. And we're going to find, and I want all of you people here and for the viewers on YouTube and social media, I want you to go find people who want reform like I do. Contact me, go through Kirk's Law Corner, and come together with us and demand reform of this broken system and begin to heal our country. The complaint or this cause of action is going to be unconstitutional laws. Every state has these. And so we're researching the state statutes and saying, you know, okay, here's what Alabama has, here's what Arkansas has, all the way down through all 50 states. And this cause of action is going to be against all 50 states. The 50 states will be the respondents in this case. So the first crux of this is challenging unconstitutional statutes. Here's the value of that. The primary jurisdiction of the United States Supreme Court is to determine whether, or to make determination when state statutes are unconstitutional. How the heck are they going to say, no, we don't want to hear that one? I don't think they can. And if they do, that's fine, because then we'll take it to Congress. I don't know, I'm doing some research on it, perhaps military tribunal, and certainly to the president, that the Supreme Court is acting in treason against the Constitution. And I don't say that lightly. Justice Peckham, I think it was 1908, in the case Ex parte Young, he said, you know, sometimes there's cases we don't want to hear, but we have to hear them. For us to take jurisdiction when we should not, or to abrogate jurisdiction when we should, is treason against the Constitution. And so I'm just reiterating the words from a 1908 Supreme Court justice saying that the failure of our highest court to enforce the Constitution is treason. And so then we'll bring that, if the Supreme Court doesn't want to hear this case, fine, we'll try some other way. Going to Congress, going to the president, perhaps going to the military tribunal. Next, we will in this case, we'll complain that there's no oversight of the judiciary, and the fact that we have no means to enforce our right of due process. So those are the three main things. We don't want money. We don't want bad people to go away. We just want them to start acting right, you know. And I think there are some bad judges who should go away. You know, the judge in my case, I actually turned him at the end, and he was ruling in my favor. He could have done a lot worse to me. He had compassion, and he stood up. There's no doubt that my judge stood up for me. But he still violated my rights and bullied and harassed me for 2 years before I turned him. Lost my train of thought, sorry. So, you know, some of these guys, they need to go away, but I don't care about that. You know, I'm not here for vengeance. I'm not here to make people pay. I'm here to restore the Republican principles that this country was founded upon, and to find like-minded people like me to join me and the others that I'm working with to add your name to this as a co-plaintiff. So if you want reform and you want change, add your name to our document and be heard in the United States Supreme Court with your name attached to it saying, I want change in Georgia, I want change in Florida, wherever you're from, Texas, all the other states that are out here represented today. The redress that we're asking for, John Refty said it earlier, we don't need any more laws. We already have plenty of good laws on the books already. We just need to enforce them, or to have the state governments, through its agents judiciary to adhere to the provisions in the Constitution. So the redress, what do we want? What are we going to get out of a case like that?
Reform.
Number one, in my mind, is returning power to the people, because the judiciary is obviously irresponsible, and they cannot handle this responsibility on their own. So we need to return the power to the people in juries. That's how we do that. So what I want is, when a litigant gets into any kind of court proceeding, I don't care what it is, traffic, family court, child custody case, the state taking away children wrongfully, I don't care what kind of case it is. We have a right, Don Rufty said it earlier, and he's right. He mentioned in our federal constitution, our state constitutions, most all of them, not every single one, but most all of the state constitutions guarantee us a right to a trial by jury in any civil matter as well as criminal matters. Of course, we still, today even, thank God, that we have a right to a jury in criminal matters. But we've been deprived that right in civil matters. And my Tennessee Constitution, Thomas Jefferson said, the Tennessee Constitution is the most Republican and the least imperfect. Which is great, because that gives me a fighting chance. You know, the Tennessee founding fathers were not sophisticated like, say, New Hampshire, Connecticut. If you read, some of the northeastern state constitutions, you can tell a lawyer wrote that crap 200 years ago because of the lingo that they use. But Tennessee's constitution was very common sense, very easy to understand, and the most Republican. And so it's giving me, standing in that fight. As an example, Tennessee's Constitution says I have an unalienable, indefeasible right to reform the government in such manner as I think proper. That's what I'm doing. And there's several other state constitutions that include that same clause. Now, the one in New Hampshire I was looking at, tricky lawyers cut that one out of their constitution. But we have it in Tennessee, and a lot of other states have that same clause. So the redress that we're seeking is when you get into a trial and your rights are being violated, you say, wait a minute, I don't feel like this stuff's fair. I want a timeout. I want all orders stayed, and I want a jury assembly in this case. And I want to return power to the people in that way. We cannot ask, and I think it would be a tremendous burden on society to say, I want a trial by jury in every single case. That we can't pull people out of their jobs like that. But the fact that if we were to win this case in the Supreme Court, and the Supreme Court to order the state governments to say, hey, they have this right. If they can stop proceedings anytime they want, because you guys have been screwing up for too long, and so. You're going to have to allow them this, that they can say, time out, I want a jury. If that were to happen, these judges aren't going to misbehave in the first place, and there won't be any need to call people out of their jobs, because a judge would be so embarrassed to have a jury come in there and say, what the hell was he thinking? No, we're not going to take this family's children away from them. We're going to stop this, relying on unsupported allegations. So that's the main redress that I want in this Supreme Court case. Another one is because the state judicial oversight agencies aren't doing their job, we need to take power back from them too. And so when a complaint is dismissed against the judge, we need to say, well, okay, but let me put that one in front of the jury now and see whether the judge violated my rights. How would that change things? So you file a complaint against the judge, stupid judicial oversight agency doesn't do their job, fine, I'll take a jury and I'll have them look at my complaint. And if we had that check and balance, we have checks and balances that are gone in this country, just like Thomas Jefferson said, until all shall render powerless the checks of one branch over the other. And clearly that's what we have right now. There's no legislative check over the judiciary or vice versa. The executives, the governors, they won't do anything to jump in the middle of this process. And so all of the checks and balances have been taken away. But I think this government was set up by consent of the governed. That's what it says. That's what it says in our Constitution, or in our Declaration of Independence. Asserts much the same. So that's what we need to do, is return power to the people and have juries oversee these dummies, because they can't do it. Not when this is really interesting. When 42 USC 1983 was enacted, I think it was Senator Perry, back in the 70s, he said, sheriffs having eyes to see not, judges having ears to hear not. All of the checks and balances put in place, all of the rights of due process, all of the principles of our law are sculpted away from as if something to be feared. And so we're going to provide what the several southern states haven't been able to provide, which is a means of redress against somebody who's violated a right of due process. Congress tried. So Congress enacted statute to protect us back in the 70s and 80s when they enacted parts of 42 USC. Out of that same time frame, I think that's when our judicial oversight agencies started getting put in place as well. And none of that stuff has worked. We have the laws there, we have the judicial oversight agencies there, but none of it's working. So the only thing that's going to work is returning power to the people. And I hope for the viewers out there watching this online over the coming months, send me your name, your address. There's no work you have to do. We're doing all the research. We're writing the complaint. We're printing the books. Everything that will get filed in the Supreme Court. The only thing you got to do is add your name. And the more names that we have, the louder our voice will become, and the greater the probability we have of being heard and demanding justice. So, thank you all.
Thank you.
I hope you guys enjoyed that presentation, because it's wonderful that there are still people out there who are not afraid, to stand, who are not afraid to talk, not afraid to be seen, not afraid of a little action. This man's ex-Marine, and that's probably why. So there needs to be more people like that. If you are such an individual and you are not being heard, my media is here for you. The show is here for you. You've got some gag orders, you got some issues. Get in the court, getting your stories heard. Please, please, I encourage you to get in contact with any members of the Truth Pharmacy Productions and email us at thetruthpharmacy@gmail.com. You can always reach me on Skype. Our studio number. We're very accessible because we are here to connect. Because these are all social issues. We can't do anything without one another. And we gotta connect despite how much isolation tactics that we're being put under here. So don't be divided and conquered. Let's unite and do the conquering. So yes, once again, thank you for viewing this presentation, and catch me next week.